My biggest fear would be when the first comes and I don't get the rent.
I found that my tenant had dumped concrete down my toilet. Can you believe Fair Housing fined me $5,000 for that?
How do you onboard your tenants? What do you do?
I don't even know if I do it right.
If you're a landlord, don't just rent, Rent Perfect. The Rent Perfect podcast with property expert and private investigator, David Pickron.
Well, hello. Welcome to another podcast here. I'm David Pickron, and I am your host today, and I'm so grateful to have Denny Dobbins here with us today, another attorney that I like. I always talk about how I have a hard time with attorney Denny's, but
So
you know, but you know, one thing about Denny and my relationship probably started 20-something years ago. Denny, I probably more than anybody in my whole life probably called you more about real estate questions and answers than anybody else, probably. As you know, I've grown up with my investment career, and I want you to know that you are like within my top 3 mentors. And so that's why I'm so grateful to share this podcast today with you. What's interesting is we've gotten along and seen the same kind of vision for so many years that I'm grateful that in the mid-2000s we teamed up and we partnered. And but before we had a partnership, Denny, you have an unbelievable career, and I almost can't name it all. So just give us an idea of where you started. I know go from when you went to law school up until you joined Rent Perfect as the vice president of legal counsel.
Okay, well, I'll go a little bit before that. I started off as a cop, and after I did that for a while, I became a private investigator with my old partner, who's a congressman. And we did that for a number of years before we both went back and got some degrees. Thought that'd be a good idea. And so after 10 years, then I went to law school. So I was a little older. And about the first year after law school, I met up with an officer from Mesa PD because I'd been a cop and I knew a lot of the guys. And he talked about this crime-free thing, and he wanted to do something to help landlords around the country, and he had some ideas, so we kicked that around, and we decided, well, let's do it, because the government had just done it. They'd done a crime-free addendum, and you had to make sure that you kept all the laws and you didn't disobey laws while you rented a property.
In public housing.
And that was Jack Kemp that did that under Reagan. Tells you how old I am. And so then we said, well, can we do it in the private sector? We thought we could. And so I developed a crime-free addendum for the private sector, and for 18 years I was the attorney for the International Crime-Free Association. We taught thousands of police departments, and then they in turn taught landlords how to implement the crime-free program. And so I did that as I built a very large, basically eviction practice. We did all the spinoff work from it. We did all the complaints and fair housing. I taught for the real estate department. I taught for the housing, public or private housing, all types of different elements with real estate and with the associations. We did all that. And I became a HUD commissioner, and that was very, very interesting to be a HUD commissioner, to see how the other side thought about housing, because it was very different than the private sector thought about it. And so did that till around 2008, then joined you with Rent Perfect and Crim Shield, and here we are.
So I remember back in those years, and I used to tell you, Denny, you're on the wrong side. I said, Denny, you're on the wrong side. You're on the attorney side, which is always the reactionary side, right? I mean, you're putting out fires day in, day out. I know there are nights I talked to you, you wouldn't sleep throughout the night, right? You had clients calling you 24 hours a day. I think you're even on special edition with a case. Was it special edition? Or
let's see, we had hard copy in 2020, yeah.
That's right. And, you know, and life became very, very stressful for you because of that reactionary state of you know, you're just so good. People wanted you to do their cases. And I kept telling you, hey, come over here to this side, and let's help the landlords find the right people and be proactive so they don't have all the garbage on the back end. Now, we can't We can't promise that you're never going to have a problem, but boy, I certainly like being on this side of the table. But guess what's happened?
Yeah.
Guess what's happened?
It's happening still.
We're
right now.
we're becoming reactionary again, and you know why? Because cities like Chicago are passing regulations that are killing us, right?
Well, what we found is when government gets involved with a problem that government created, the problem gets worse.
Right. So this podcast really has taken us a while to get to the subject, but this podcast is really to talk about Chicago and where Chicago is going. And I think Chicago is thinking, hey, we have a lot of homelessness and we have a lot of people with criminal histories that are being prevented from having a roof over their head. And so instead of us coming up with a solution, let's push this off to the landlords and make it the landlord's problem.
Right. We'll come up with a solution. We'll tell the landlords what their solution is, and then we'll force them to implement the solution we came up with.
Right.
And that's what they've done.
So, I'm big into this American freedom. I'm free to do this. I'm free to do this. It's my property. I can do what I want. It's changing, Denny.
The government's taken over housing, 30, 40 years ago. They took it over. And landlords, if they want to get in the game, they have to follow the rules or else they get taken out of the game.
Right. And also, I also noticed that we used to always talk about, HUD and federal, and then all of a sudden a few states passed some FCRA stuff, and that's Fair Credit Reporting Act stuff, or kind of regulations for that state. And now Cook County, right, is now passing this fair housing ordinance. And cities now are coming in with city councils and making their own rules and regulations. And for a landlord, how in the heck do we keep up with it all? It's just absolutely crazy. But let's focus on this Cook County ordinance. Tell me what you know about the Cook County ordinance.
Well, it's fairly simple, really. They basically come in and said, hey, look, we're going to take your federal rights away, and we're going to implement certain issues where we're not going to let you follow the federal laws. You're going to have to follow our laws. That's going to wind up in a lawsuit because there's a preemption that the federal government has over the states and cities and counties. But nonetheless.
So federal guidelines say we can report a conviction as long as we want, as long as it's a conviction, and we can report anything else up to 7 years. But if it's not a conviction, we can't report after 7 years. That's
right.
Federal.
For a fair credit reporter,
right?
You can do that. You have to
Right.
follow those laws. But this is worse because now they're going to landlords and they're bypassing the people like Rent Perfect because they're saying, we don't even care about that. We're not even going to let you look at that. Not
Right.
only they can report it, but you can't look at it, and you can't use it.
Yeah, it makes no sense.
Doesn't make sense.
Right.
So the federal government allows certain things to be done. The state, and in this case the county, is trying to limit. They pass something to try to limit what the federal government says you can do about housing.
Okay.
There's going to be some problems down the road, but for now, until that's taken care of, the Cook County says 3 years. You can look at criminal history for 3 years. That's it.
And it's 3 years from the conviction date, which is so important. A lot of people don't understand this. HUD came out with some guidelines years ago that said, listen, you really should go 7 years back, but 7 years from the time they got out of prison, from their last day of parole, right? So it's almost like 7 years for them being out into society to prove that they have changed. But when Cook County says 3 years from conviction, that means 4 years ago, armed robbery, I go to prison. The day I get out, I'm eligible.
You're ready to go. So there's two things to look at. Some people say, well, they served their time. They paid their price to society, so they're done. Other people look at it and go, well, when you go to prison, that's where you learn how to be a really good criminal. Because what do you do when you go to prison? You might join some group that helps you, but generally you're learning from everybody else that's in prison. That's a problem. So when you get out, you could be a real problem.
Well, and I look at it too, when I study recidivism rates, 2/3 of people are going back to prison within 3 years, right? Now, maybe some people would say, hey, well, that's because they can't get a job and that's because they can't get housing and that's part of the problem. And I can see how they can make that argument. But I don't know that I want to be the one that they recommit the crime with. I don't know that I'm going to be the one to want to show them the house and have all this communication with them, eventually tell them, no, you can't live at my property, make them mad, and have to deal with that. I don't know if I want to be with me or if I send my wife out there. I don't want people in danger.
Well, that's not really the problem that Cook County and these other counties and states and cities are looking at. They're not looking at how to protect a landlord or staff or
Right.
other tenants
Right.
that are in the close proximity to where this person's going to be living. What they've decided is, well, we've got this problem. We have a homelessness problem, and we have a problem for criminals having a place to live when they get out, and we need to make sure that they can be successful, because the two things they need is a good place to live and a good job. But they're saying, okay, well, we're not going to take that responsibility anymore as a city, as a county. Landlords, you're going to take that responsibility for us for free, because you're playing in, our sandbox.
Right.
So you're going to do it for free for us, for the city. And what they don't even understand and what's happening around the country is they're making the problem worse.
Absolutely. Absolutely. So let's go through it. We've gone through that. We've established we can go back 3 years, but let's start from the very beginning. So I'm a landlord. I have a home. Let's say it's an A property in Chicago, Cook County. Okay. It's available and it's ready to go, and I market it for rent. So I get a phone call, and what should I do and what shouldn't I do on that phone call?
Well, the first thing you do is you provide the person, it's a fellow, you provide this fellow an application and say, here's the application, and fill it out. Now, on the application, that's key. Can't have anything about criminal history.
Okay, but even before the application, I'm probably going to have a phone call where I set up an appointment to show the property.
Right.
Right.
You're gonna show the property, and you
Right.
want and under this new rule, you have to give them your criteria.
Okay.
What's going to be your criteria for being able to live here? And it's actually a good thing in a way, because they need to know, and it could act as a deterrent, because once they see it, depending on what your criteria is, they could say, well, I'm not gonna qualify, so I'm not even gonna waste my application money or my time.
Right.
So
So you're going to treat everybody fairly. You're going to go through and show everybody the property the exact same way.
Yes.
You are not going to talk about criminal history.
not even if they want to talk about it.
Not even if they tell you the story.
Don't just say, hey, that's not even an issue here,
That is irrelevant at this point.
because they could be setting you up.
That's true, because there are shoppers out there, and there
Yes.
are people that are setting you up. Okay, so at that point, we get to you give them the application. But before you give them the application, we talked about it, you give them also your criteria. Denny, what is a criteria? For those who are listening, maybe thinking about getting into this business, or maybe have one or two units and say a criteria, I just usually see if I like the guy or not, and I just rent to him. What is a criteria?
Well, criteria could be very expansive or it could be very limited.
Okay.
I like expansive because, I'm a lawyer, so
Right.
I like to write all that stuff in there. But the bottom line in a criteria is you're going to have, you want your FICO score. Okay. You want your credit information.
Okay.
What's the financial situation? Because you're about ready to give anywhere from a $50,000 to a $200,000 asset to this person that you don't know,
Right.
that you're not going to know anything about whether or not they have criminal history and what it means, what kind of criminal history it was.
Right. And for those who are wondering about scoring, about 700 buys your home. 625 score is about your average renter. 550 and below is you're not really paying many people. And so on your criteria, I usually recommend that you would say an approved, conditional, and declined. And so you would say like, hey, 625 and above approved, 550 to 624 conditional, meaning I'm going to look at your job, I'm going to look at some other stuff, and you're kind of in that gray area. And then like 539 and below is declined. Now, I'm not telling our listeners that's your criteria. I'm just telling you, I'm giving you an example of how that would look on a criteria sheet.
Right. In fact, anything we say in this podcast, especially coming from me as an attorney who's not licensed in Illinois, you've got to take this information to your attorney, ask them about it, get it approved, and then deal with it. But one of the things in that criteria is not only the FICO score, but one of the ways you can protect yourself against this new ordinance is, well, how long have they been on the job?
Okay.
And what kind of job is it?
Okay.
Because people have just come out of prison, this is very typical. They just don't have a good job. And guess what? They don't have good credit, if any credit. So that's going to cut out a lot of the criminal problems right off the bat that this ordinance doesn't even cover. And one of the reasons it doesn't cover it because it really can't.
Right.
What are they going to do? What's a city going to do? Say, okay, landlords, you cannot use FICO scores. Anybody above 400 gets to rent. Everyone would leave Cook County. There would not be a landlord left.
They're all leaving now, Danny.
Yeah, they are. And you'd have even worse blight. So they really can't go there.
Right.
And so they don't even realize that this ordinance doesn't take care of the situation.
And rent to income ratio too, I think, is another one where, how much is your rent and how much do they need to make in order to pay the rent and their other bills. Now, where I see that this is going to get a little bit of muddy is most people coming out of prison or have a criminal history usually aren't applying by themselves. Usually they're doing it with some other people. So they might be able to make that rent to income ratio, right? But that credit score, it might be tough to hit because if you don't use your credit score within the last 6 months to a year, you have a 0 credit score.
Well, one of the things you can do, let's say that several people are going to live in that apartment unit or that single-family house or that HOA property, whatever it is. You simply say as part of your criteria, every person must meet this criteria because there's nothing prohibitive about doing it like that. That will help ensure that you don't get someone with really bad criminal history there.
Okay. And I think criteria is good to say whether you allow smoking, whether you allow pets, right? If you accept evictions, rental collections should be all in there.
All of it. Everything that you can think of.
Now, Danny, in you researching this new Cook County law, can I give them my criteria for criminal history even though I can't talk about it?
Well, what the statute says is that you must.
Okay.
It says you have to give the criteria. In fact, my look at it is if you don't, they could have a case against you for violation of the actual ordinance.
Of not giving a criteria.
It says you have to give the criteria. Part of your criteria is the criminal criteria. Now, you're not asking about their criminal history.
Right.
You're just saying, okay, here's my criteria. So you're following the law.
So I'm gonna be showing my home. I'm gonna give the criteria. They're gonna look it over and they're gonna go, okay, criminal history in the last 3 years. Hey, listen, I have a theft charge 2 years ago. What would be your recommendation?
Well, you know what? That's really not an issue today. First thing we have to do is let's see if we can get you pre-approved based on the other criteria. Anything to do with criminal, that only happens after we get a pre-approval.
Okay, so we're only in phase 1 now, and I want the Rent Perfect Nation to understand in phase 1, criminal records are not even talked about. It is just not even though you have to give the criteria, you do not continue the conversation.
It is not practical.
Not practical.
But that's what you do. Because they may be taping you.
Yeah.
You have to realize in today's world, it's pretty easy to take your iPhone or Droid out and just press the button.
Record the world.
Everything's being recorded. You know how it is. You see it on TV. And you could be recorded. And if you don't say something like, that's not something we talk about now. And if you go into it, ask questions, even listen to it too much, it could be a violation. So we got to be careful.
And this is a little off topic with Chicago, but we always teach never have 2 applicants show up at the same time and never show your property to 2 applicants at the same time. Just one at a time. Give yourself a half an hour in between each of them. Don't even have them cross each other in the parking lot. There's just a lot of reasons for fair housing. And they're just watching to see how you're treating them and how you're treating me. So just keep that in mind. This is no different in Chicago as you're showing your property. Okay, so we take the application. What actually can we do now once we have an application?
Once you have the application, then you go through all your criteria except for the criminal criteria,
Okay.
and you
So I can run the credit.
you can run the credit. Whatever you want to do, whatever's your criteria, you go ahead and do that.
Okay, perfect. Then I can call the employment history
Yes.
and make sure they got a job and how long they've worked there and all that
Yes.
good stuff. Get the W-2,
Everything.
right, or check
Yep.
stub. I can call past landlords.
Yes.
Okay.
Make sure you get that second past landlord.
Yeah, that's true. The
Yeah.
first landlord might say he's great because he just got to go.
Got to go.
Got to
Right.
go. Okay. And, so I can do everything but criminal history. And then once I say, hey, this seems like this might work, what's the next process?
Well, once everything does work, you have to give them a notice saying, hey, I've run all your criteria for financial, and either you passed or failed.
Okay.
So you got to give them that
Passed or failed the pre-approval.
pre-approval.
Okay.
Okay, and you have to do that either in person or by some kind of electronic way, like text or email or something, or you could send it certified mail. I would do it return receipt requested, but that will take forever.
But the statute does just say email, text, phone call?
Phone call will work. Check your state. I'm not exactly sure on Illinois, but you could tape that phone call if your state allows it. Most states are a one-person state, meaning if one person's on the phone call, they can tape the phone call if they're part of the phone call.
But we'd always recommend in writing, which is text, email,
Yes.
mail.
That's the way I would do it.
Just get it in writing.
If you
It's
did
just
that,
so much easier.
you're safe.
Okay, perfect. So I like a guy, not me personally, but I like his application. It seems like he qualifies. It seemed like he'd pay my rent. It seems like he'd take care of my house. Now I come back to him and say, hey, you're pre-approved. Now I need to get your permission to go on to phase 2.
That's correct. You're going to get an authorization
Okay.
that they're going to have to sign, giving you permission to pull their criminal report, meaning their consumer report, to find out. Now you can go out and look to see where they've had, dealings, where they've
Right.
lived, and then you can go to those courts, and you need to go to those courts.
Right. Have your screening company.
Have your screening company, go to the courts and see what's there.
So what's going to be a big problem right away here, Denny, being in this business is a lot of companies will give you 7 years worth of data. Okay. They're not going to give you 3 years worth of data. So what happens when a landlord uses a screening company and gets 7 years of data, sees a guy has an armed robbery 5 years ago, sees it, they know it, but they can't use it?
They're in a pickle. They're in a real pickle, because here's the situation. A lot of things can happen, but they can see it, but they can't use it. Now, let's look at that from a practical point of view. Is that going to happen? They can see it but not use it? Not a smart thing to do. The better thing to do is just get what you need.
But knowing the screening industry, we're
Yes.
all going to have to change
That's right.
our algorithms, and it's January. This just went into effect 21 days ago. It's still going to be 3, 4, 5, 6 months before someone gets a Chicago report,
Yes.
right?
Now, if this thing goes to court, let's say this person is denied. This applicant is denied, and they have something from, let's say, 4 years ago that came up, and they get denied. And what are they getting denied for? The landlord's either going to have to make something up.
Well, you've already pre-approved them on credit
you
and
pre-approved
everything,
them.
so that's
You pre-approved them.
you can't go
So-
back there.
So you're in this pickle.
Yeah.
I'm stuck with this person.
Yeah.
So if they don't rent to him, it could be a lawsuit. And what are they going to see? They're going to see that they got this 7-year report or this 10-year report, and that's what they used. They're going to be toast.
Right. Now, Denny, here's a problem, though, that I have. Okay. I know that if I do rent to him because I have to, I can only go the 3 years. But I have a multifamily project, a fourplex. And that guy then goes and causes damage to another one of my tenants. Am I going to be liable for that?
Well, that's an interesting question. Let me take it from a different angle. The first issue is do you have a duty as a landlord to the other tenants to even run a background, to even go through screening for criminal? Do you have a duty to those tenants?
I think you do.
The law says you have a duty. It's a duty of reasonable safety. That's the general negligence law. The next thing that will be looked at is, well, but for your actions, would this thing have even happened? Would this event have even taken place? Meaning, would this person have been hurt by this new resident?
Right.
And the last thing they look at is, well, this person that you put into the property, allowed to rent there, who had this criminal background, was it foreseeable that the landlord would have known that this person could have harmed this person? And that's where the landlord can then get sued for negligence.
But will I have a defense saying, guys, I can only go back 3 years? Is Chicago giving me, or Cook County giving me that liability defense saying, hey, sorry, other tenant, I could only use 3 years?
Right. Well, here's a couple of issues that come up, and I can see a whole bunch of things because, you know, when lawyers start thinking about these things, they come up with all kinds of stuff. The first thing that the landlord would say, well, gee, I have immunity because Cook County made me do this. They made me put this guy in. What am I going to do? I can't deny him now. And Cook County's going to go, well, we didn't give you immunity. So what do? Do you sue Cook County? Does Cook County now become an entity to sue? No, that's an issue that we don't know. I mean, maybe an attorney might take that on to say, you put in this ridiculous, illegal ordinance, so we're gonna sue you, Cook County, and somebody could make a big deal out of this. On the other hand, the landlord could say, well, you know, yeah, I did what they said, and the resident's going, well, it doesn't matter because you got a report for 7 years back. You knew about this.
You knew about
and
it.
you didn't tell us. We don't want to live here with this guy here.
And that's why you don't want to report over 3 years. So yeah, this 3-year report, Denny. I mean, even if we find criminal history on that 3-year report in phase 2, which even throws a wrench in there, we have some analyzing we have to do to prove that they would be a detriment to the property or the people around there. So let's get into this now. Phase 2, analyzing the criminal history. What is the process now? So they've gotten pre-approved on the credit side. Okay. We've now got permission from them to run their background, rerun their background, and there is some sort of criminal history. Let's say, example, a year ago, a shoplifting charge. Now what do we do?
Well, right now, we're not going to do anything. What we're going to do is we're going to hold that information. We're going to send that information to the applicant, and the applicant can look at it, do whatever they want with it, but we're not going to do anything for 5 days. Once we mail it to them, email it to them, text it to them, however we deliver it to them, hand deliver it to them, they're going to have an opportunity to look at that and dispute it. If there's something in that consumer report with criminal history that they think is wrong or that they think is not relevant, those are the two things, that it's not accurate or that it's not relevant, they have an opportunity to dispute it. So the way the statute is written, maybe they didn't intend to write it this way, but it appears we don't want to get in trouble, so we need to follow it very specifically, and so we just need to hold it for 5 days.
Okay, now let me just throw in there. You know, I am always really concerned about people's private information. But I also want proof in writing that I gave them a copy of their report, right? So as long as that report has a social security number redacted, maybe the date of birth redacted, I'm okay sending it by email and even asking for a response.
Or they could have a portal. They could go in and look at it.
Right, and in Rent Perfect.
It's electronic.
Right, and in Rent Perfect, they have a portal. They get it automatically. But not everybody uses Rent Perfect. So we really want to come up with an idea and a plan that even the people that don't use Rent Perfect do it the right way. Rent Perfect's got you covered here because once the background's ran, both parties get it at the same time, and there's proof in their portal that they do that. So I appreciate you bringing that up. But I would make sure that I documented that I did send them a copy of their background.
Right, and if you do it by email, you have your documentation. So
Perfect.
That's the easiest way.
Perfect. So we're going to give it to them. And as a landlord, I want to give it to them right away because I want that clock to start ticking. Or you could wait the 5 days if you had another applicant coming through, right? And you could delay it out. If that other applicant looked like a better applicant, you could rent to them. The law says that you don't have to hold it up.
Right, but there's two things that we need to be careful of.
Okay.
I think what you have to do, what this ordinance says, is that as soon as you get it, you have 5 days to deliver it to them. So
Okay.
you have to deliver it to them.
Okay.
At that point, the ordinance is silent as to, well, what do you have to do? Is there a time period in which you have to do something in terms of the individualized assessment? No, there's not. You don't have to do anything. So you want to wait the 5 days, because once you send it to the occupant, or to the applicant,
Mm-hmm.
then they have 5 days to come back to you and say, hey, here's my proof that this is inaccurate or it's not relevant. It's not something that should hold me back from being able to rent your particular dwelling. Now, if they don't come back with some proof, and when we talk about proof, this ordinance doesn't explain what proof means.
Okay.
So the way we should look at it is, if they come back with anything, I mean, any kind of evidence to show that the crime is too long ago, and we know it's not going to be because it's a 3-year deal and that's all we're looking at.
Right.
But what's the nature and gravity of the crime? How bad was it? Were they somehow disabled when the crime was committed? Or were they really young when the crime was committed? Anything that might mitigate the relevancy of that being held against them, or anything that might show that this particular criminal act is not accurate, meaning that maybe it was someone else, or maybe they pled down to something that's not showing in the record that we pulled up, because we need a chance to look at that and make it right. I mean, nobody wants to hold something against anybody that's not right. So they have 5 days to do that. They have to give the landlord the information that evidences that this is not relevant or that it's not accurate. So after that 5 days is up, now we could be looking at other applicants that do qualify. And we could go ahead and rent to some other applicant that we don't have to deal with all this. And that's totally within the statute or within the ordinance. But once the 5 days is up, let's say you don't have anybody else, or you do, it doesn't matter, but when do you have to do the individualized assessment? It doesn't say. The ordinance does not say. However, if you're going to be renting to anyone, at some point you're going to have to do an individualized assessment.
Per HUD.
For
federal.
HUD.
Yeah.
You got to do the federal one.
Right.
And the federal one is very, very similar to the Cook County. They're really no difference. It's the same idea. The only difference is Cook County added relevance.
Okay.
And they made it specific relevance. In the federal, it's inaccuracy or misleading.
Denny, what is relevance? I mean, to you as an attorney, what is relevance?
Well, I think what relevance is let's say this person got a misdemeanor for DUI.
Okay.
Well, is that relevant to that person being there? Well, if it's single-family dwelling, maybe not.
Maybe not.
If it's a multi-family community with lots of kids running around, maybe. That's why it's called an individualized assessment. You're trying to figure out how does it have a relevance upon that person being at that place.
And maybe 4 DUIs could say you have a drinking problem, and you're going to be running around my community drunk.
Right. If they have 4 DUIs in 3 years, they're probably not applying because they're probably sitting in prison. But yeah.
The point is
the more they have,
individual assessment,
the worse it is.
Okay.
Or maybe it's a shoplifting compared to a burglary. And a lot of these more liberal groups are calling those kind of things survival crimes. Now, nothing's mentioned in this ordinance about a survival crime. I'm not exactly sure what it is, but it's some kind of petty thing, like stealing a loaf of bread because your family's starving.
But if your criteria is set right, a survival crime, they're probably not going to match your rent to income ratios, your credit scores. That's probably going to work itself out in most cases.
In most cases, that won't even be an issue because your FICO score is going to be high enough, especially if you're an A-B property. If you're a C and D property, you're probably leaving Cook County and you're not even going to have your property anymore there because it's not worth it. It's not worth it because you have to do the criminal background regardless because HUD requires it, because negligence law requires it. So it's not like suddenly this particular ordinance says, oh, I can't do, criminal backgrounds anymore. In fact, what it says is just the opposite. I must do a criminal background. I have to do it. There's no way to get around it. You have to know what's going on.
Can I take you back as a landlord for a second? We talk about this evidence and this relevance. And I think where we get in trouble as landlords is we think we have to relitigate the case. And, so they come back and they say, oh, yeah, I had a bad attorney and he just told me to take that lesser charge. I really didn't do it, but I really didn't have the money to fight the case. And so he told me this wouldn't hurt me. And so I just took the lower case of burglary, let's say. And now it seems to me that the burden cannot shift back on me because as a landlord, I have no way of knowing whether that's truth or not truth. And so what would you require somebody to give the landlord? I want to keep that burden of proof in the applicant's hands to prove to me what happened. Everybody does not always tell the truth, right? And I don't want to get in a position where this Cook County ordinance is saying, oh, you should accept his explanation as relevance when I really don't know if his explanation is the truth.
Well, it's a good question. And, of course, as in any legal question, it's multifaceted and it's case and fact specific. But if you're talking about the proof, the evidence of whatever it was that happened, well, for instance, let's say it's rehabilitation, and they say, well, I'm rehabilitated. Well, then they're going to have some kind of document to show that they've been to classes, they've done everything the courts have asked them to do, and they have a rehabilitation certificate. So that's going to be some kind of proof. Does that mean you have to rent to them now? No. It just means that they have a certificate that shows they're rehabilitated. Well, if they're a rehabilitated murderer, does that really matter? Maybe not. Maybe it does. But that's for the landlord to decide.
Right.
They get to choose.
But that puts us in a bad situation if we don't require that documentation. And so I just want to tell all of our clients, our Rent Nation, I want to tell them, guys, we're not taking people's words for it. They have to come in with something of physical proof. And I would even recommend that you validate where that document came from.
Oh, definitely. That's always, people with today's capabilities with computers and such, they can create anything. So what I always do is either myself or one of my folks, we verify it. We call the actual place on the document says that they actually signed this and produced it. And I've actually gotten these people on the phone and said, do you know this case? Do you know this person? Can you tell me that this is an actual document? And if they can't tell me that, then I can't say it's an actual document. But I also, make sure that I document everything I did. Everything I did is down so that if the case ever comes to court, I can say, look, I used more than just reasonableness. I went overboard to try to figure this out, and I couldn't even figure it out. And so if I can't verify it, I've done everything I can do to help.
Okay, so this is the process that happens within the 5 days. Now, once they give us the documentation or whatever they give us, we have 3 days to make a decision. That's not 3 days to go research whether they're telling us what they're saying is true or not. It is we're going to take the facts of the documents that they've given us and we're going to make a decision within 3 days.
That's correct. You have to approve or deny within 3 days. And so you take all the information that you got, you make the best decision you can make based on the information that you got. Now, here's kind of the good thing. Let's say that you say, I'm not going to approve. Well, that's fine. They get an adverse action letter, and guess what that tells them to do? Go talk to Rent Perfect, because if you say it's inaccurate, that's really not you, or that wasn't what the case was, well, now under federal law kicks back in. Now Rent Perfect has to go back and do a reinvestigation. It's awesome.
Right.
So there's another safeguard there.
Which is off the landlord, back on the screening company.
That's correct. If the screening company, and it's not usually the screening company that makes the mistake, it's the court, that it's somehow wrong in the court system. And that happens all the time, that they didn't properly docket it or document it in the court system. But that can be ferreted out. It takes some time sometimes, depending on the court, because some courts are great to work with and some courts are just not that good to work with. So now the landlord's off the hook. And now if there's a problem, not with relevance, because the call for relevance doesn't have anything to do with the background screening company.
Right. This accuracy.
For accuracy. Relevance is the landlord's sole call. And there's nothing in this ordinance to say, well, this is relevant and this is not relevant, or that's relevant, but that's not relevant. So you have to make the determination as a landlord, and you're going to just need to be reasonable. What is reasonable? It's called the reasonable man or woman standard, and it's what an ordinary person would do in the same situation and the same circumstance.
Okay, now I know in the statute also, your adverse action letter, which is your letter at the very end that's going to say, I've chosen not to rent to you. This statute wants you to say why.
Yes.
Instead of just, no, sorry, we didn't pick you. It wants you to lay out the reason why.
You must lay out the reason why. And it goes to two things. It goes to potential harm to person or property, basically. And you're going to have to, this is where the relevance issue comes in. And you're going to have to explain why you didn't rent to someone with let's say it's an arson charge. And you're going to have to say, basically, because you burned down a building in the past, we cannot assume the risk that you won't do that again and hurt someone or hurt our property. And that's pretty reasonable. The Cook County would have to come in and say, well, we don't think that's reasonable. And you're going to wind up in litigation. We don't know what Cook County is going to do. It's too new. Right.
And I know that, the big ones, armed robbery, murder, rape, assault, those are going to be fairly easy for us to say, it's just there's not enough time passed. We don't know that you're going to recommit against another person on the property. I'm concerned about the littler stuff, the shoplifting, right?
Yeah, there's all types of thefts.
Yeah, so theft in general, as a landlord, am I going to have my dishwasher there when you move out? Are you going to take my light fixtures? Or I'm just worried about theft. And theft for me personally as a landlord, I have an issue with it. Is this Cook County ordinance going to have an issue with really me having an issue with theft? And I know you don't know
hard
the
to know at
answer,
this time. Yeah.
But what would my adverse action letter look like?
Is that basically you can say it how it is. You have let's say it's a misdemeanor, because those are the harder ones. Felonies in 3 years, that's not really hard. Felonies, pretty bad. A misdemeanor can be all over the map. Now, it does not include any type of diversion. Okay. So diversion's not in there, which says, hey, look, a judge is saying, you don't qualify for diversion. This is too bad to give you a diversion. So we're not going to give you a diversion of any kind, which means you got convicted. You either pled guilty, pled no contest, or you went to trial and you were found guilty. Well, that's pretty bad too, because you didn't get a diversion. If it wasn't that bad, you might have got a diversion.
But we can't count diversions even within the 3 years.
That's correct, and that's why I'm saying that if it wasn't a diversion and the judge thought it was bad enough to give you the misdemeanor,
that's good enough.
It's not real good for you as an applicant.
Right.
However, the point is still taken that let's say it is a shoplifting. Well, is that bad enough to say, hey, we don't trust you, we think you're going to steal our ceiling fan when you leave? I don't know. It's a judgment call. And my thought is, because I've also been a landlord, as you know, if they've got a misdemeanor in 3 years, that's bad enough to say, I don't trust you. And so you just gotta write out what happened, and I don't trust you with my property or anybody else's property or with any person.
Right.
But let's say it's something else. Let's say it's like fraud, felony fraud, or misdemeanor fraud against the government. What do you do with that? I think same thing.
So they're going to fight relevance, and then you're just going to have to lay out.
You got to lay out the reasons why it goes to property or to person.
And I don't usually like to give, I know every property is different, every landlord is different, every situation is different, but I'm really looking for responsibility. So it's not so much that it's shoplifting, or it's just the type of person who would make those choices. I don't want to be a business partner with. I don't want to sign a lease with, right? And laws like this are really muddying the water for me to really get in a lot of trouble.
And it also gets us into a whole nother realm of why they're having these ordinances anyway. You have tenant groups that are saying, hey, we as criminals are not getting good places to live. And sometimes they're saying that, we're homeless. And the reason we're homeless is because we can't get a place because they do a criminal background.
Right.
And it makes the issue something that really isn't what the cities think it is. Because as soon as you start messing with the C&D properties where most people with criminal histories go, and they feel like this is onerous on them, guess what? What's happened across the country is now those C&D owners are selling the properties, and sometimes the cities are saying, well, we don't want these C&D properties here anymore, so we're going to, scrape the land and make them build a better property, which exacerbates the whole problem.
Because it's more expensive rent.
Exactly. So now they have people on the street even more so than they did before they started passing rules like this.
I tell you what are our politicians thinking? I wonder if any of them own rental property at all as they go through this. They're actually creating the exact thing they're trying to fix, and I don't know why they can't see that. That's crazy. Well, Denny, we worked with the Chicago Creative Investors Association. We worked with their attorneys. We spoke with a lot of landlords, their association's presidents. They did a really good job, kind of trying to give us the play-by-play as this whole ordinance worked itself out, which is interesting because most law gets passed in April, and then they give you so many months to kind of, make sure you're in compliance by January 1st. These guys were changing the rules in October, in November, in December, and they still stuck with this January 1st rule. So we're taking the best knowledge that we have right now that they have given us, but I am sure some of the stuff we're talking about is probably going to get clarified in court by some judges. I think this isn't done yet. What do you think?
Well, I don't think it's done yet either, because the tenant groups always want more. The landlord groups always want less. And as this becomes implemented, the unintended consequences are going to start being seen. The question is, will the county see those unintended consequences for what they are, or will they even exacerbate the problem more by changing it in a way that doesn't fix the problem? It's hard to fix a problem like homelessness and criminal activity. I don't think you can put it on the backs of the landlords like they're trying to do. It's not going to
add
just
mental
go away.
health in there too.
Yeah,
right?
mental health is huge. I mean,
Right.
we can't fix that on the backs of the landlords. That's a social issue that we have to come together to do, and we have to have the funding to properly house those folks, because even when you house mentally ill with the private sector, they can't keep the rules.
Right.
They just can't. They want animals, and there's nothing wrong with having an animal if you have a disability, but they can't control their animals. We've seen over time, and other problems occur when you have the mentally ill in private property. It just doesn't work very well. So we have to focus on what the real problem is and come up with solutions for the real problem, not just dump them on the landlords.
Well, I tell you, I think being a landlord and an investor is the best business in the world, and I say that all the time. And I still think it is, right? But I'm not putting any money into Cook County. There is no way, when the rest of the country is a lot more on my side. Here is my issue. Is this going to spread? Is this going to go from Chicago to St. Louis to Oklahoma, into Texas, into Arizona? Is this going to spread? And that's why we're keeping our eye on, cities like Seattle, Chicago, San Francisco, Portland, Oregon right now, Kansas City. And we're going to have a separate podcast on each of those cities and what those cities are doing here, in the short future. So today we're going to really focus on Chicago, but we've talked about a lot today. This has been our longest podcast yet. And my goal is usually about 20 minutes. We're well into almost an hour. And I want to close with this. I want to say that the Chicago Creative Investor Association, they actually have a document. It kind of is a step-by-step, check-mark off document that you can get from them, that we help them create. It starts from anywhere from putting your property for rent, to meeting the people at the property, what you should do, to giving them the application and the disclosures that are required by this Cook County law. It takes them through the background, the pre-qualification. It takes them into phase 2, the criminal background, the days that you have to wait. So it's a really cool document that kind of takes this confusing process that wasn't written well at all, which is crazy. So if you're still kind of confused and you're thinking, man, you guys have talked about a lot, we've tried to make it as simple and clean as possible, but it's a lot of information. So contact Jane Garvey. She's been great over at the Chicago Creative Investor Association, and ask her for one of these checklists. And if you just stick with the checklist, I think you're going to be okay.
Yeah, it's a step-by-step approach. It's actually easy to follow. And if you do it, you're going to be just fine. I mean, all you have is another set of requirements on top of the old federal requirements. They kind of mimic each other. The only thing that's different is that there's a few days in between things that you can do and notice to the applicant. And other than that, they're really very similar. It's just not taking care of the problem that Cook County wants to take care of. Perfect.
Well, Denny, I want to thank you. We got many podcasts to do. Your knowledge is just amazing of what you have, what you know around the country, with who you deal with. I want to thank you a whole lot. Contact Jane Garvey over at Chicago Creative Investors Association or Rent Perfect, and we'll get you in touch with them. You know what, guys? If you like our podcast, go ahead and subscribe to our podcast. Link to us out on YouTube. We'd love to talk about topics that are going to bless your lives and bless your investing lives. And until then, continue to rent perfect.